Namaste. This is the first of three pivotal judgments requested by the Supreme Court, as it deliberates what must surely go down as a landmark ruling in the MC Singla case SLP C number 5561 2016. I'm Priya Chakraborty and my co-host is Anil Agrawal.
Today's podcast will dissect the very important Rajasthan High Court, Jaipur Bench judgment in the case. State Bank of India Pensioners Association versus State Bank of India and others. Case DB, Civil Writ Petition, number 129 2017. Judgment date, 28th February 2023. Sitting on the bench were Honorable Justices Pankaj Bhandari and Rekha Borana.
Today we are tackling the significant High Court judgment concerning PSB pension updation, and it could change the fortune of potentially millions of bank pensioners. We're discussing a ruling from the Rajasthan High Court, the Jaipur Bench, dated back to February 2023.
The case name is State Bank of India Pensioners Association versus State Bank of India and others. Now, I know that sounds maybe a bit dry, like pure legalese, but our mission here is critical. This deep dive asks, can a huge PSB, like SBI, just let retirement benefits wither on the vine while current salaries keep going up? Is that fair to the elders of India's banking?
It's a fundamental question, really, and when you look at the documents, the core conflict jumps right out. You've got the petitioners. These are retired bankers from SBI, represented by their association. And their lawsuit, it's very straightforward.
They're saying, look, our pensions haven't been updated ever, or at least not in line with how salaries for current employees are revised year on year to keep pace with inflation and other factors.
Right. Decades go by, and the gap just widens. Someone retiring today might have a decent starting pension, but someone who retired, say 20 years ago, their pension value has been seriously eroded.
It feels like their years of service have been forgotten, financially speaking, and they weren't vague about what they wanted. Their demands were very specific. 3 main points.
Okay, what were they?
First, pension updation. Simple concept. Make our pensions reflect the salary revisions that current employees get. They pointed to models like the Central Pay Commission, the 7th CPC as examples.
Basically, the same standard used for central government pensioners. Makes sense. What's the second point?
Second was about dearness relief, or DR. Specifically, they wanted 100% DR neutralization for retirees who left before 2002.
Okay, let's pause there. Dearness relief DOTA. Can you quickly explain what that is for listeners who might not be familiar?
Sure. Think of DR as your pension's inflation shield. Prices go up. Food, rent, healthcare, everything. DR is supposed to adjust your fixed pension amount so you don't lose purchasing power.
Right. So it keeps your pension relevant to the actual cost of living.
Exactly. And 100% neutralization means that adjustment should fully cover the impact of inflation.
Got it. So update pensions generally, fix the DR for pre-2002 folks. What was the third demand?
The third was about enforcing a specific rule. Regulation 56 of the SBI Employees Pension Fund Regulations 1995. Their argument was, look, you have this regulation for reviewing pensions. Use it.
So they felt the bank wasn't even following its own rules?
Pretty much. And the court, right from the start, seemed to get the gravity of the situation. There's a quote from the judgment that really sets the tone.
What did they say?
The court observed, we find that stagnation of pension in the face of successive wage revisions contradicts the objective of financial dignity in retirement.
Financial dignity, that's a powerful phrase. It lifts this beyond just numbers and regulations.
Absolutely. It signals the court understood. This isn't just about payouts. It's about ensuring a dignified life after decades of service. It frames the pension as deferred compensation, not charity.
Okay, so let's dig into that. Regulation 56. This seems like it was the key legal battleground. Did it force the bank to revise pensions or just give them the option?
That was the million-rupee question, wasn't it? And the court's interpretation was quite nuanced, actually. They agreed with the bank on one point. Regulation 56 isn't an automatic trigger. It doesn't mean every time a current employee gets a pay hike, every retiree instantly gets one too.
So the bank could say, see, we don't have to.
Not quite. The court immediately added a crucial caveat. They said you have to read Regulation 56 in the context of evolving pension law, what they call pension jurisprudence. And based on that, the court found that Regulation 56 actually creates a framework for considering pension revision whenever, and this is the key phrase, circumstances require it.
Okay, framework for consideration versus automatic trigger. That sounds like a lawyer's distinction, but what's the real-world difference?
Huge difference. Jaipur dismantled the bank's main defense. SBI and the government had often argued that without a new bipartite settlement, that's the industry-wide wage agreement, they weren't obliged to update pensions under Regulation 56.
So they were using the absence of one specific type of agreement as a reason to do nothing.
Yes. But the court said, no, you can't do that. What's fascinating is the court called Regulation 56 an active framework for revision, not a dead letter. They even cited other cases, like MC Singla, to back this up. It means the regulation is live, it's operative, and it demands that bank actively consider pension revision when circumstances warrant it, regardless of whether a BPS specifically mentions it.
Okay, so the court basically told the bank, you can't hide behind technicalities. This rule means you must give serious thought to updating pensions.
Exactly. It puts the onus back on the bank to justify inaction.
But if it's not automatic, how did the court ensure the bank wouldn't just consider it and then say, now we're good? How did they connect this back to the actual need for revision?
That's where the dearness relief issue comes roaring back. The court used the blatant unfairness in DIR treatment to show that circumstances absolutely required revision. Let's get into that DIR disparity now.
Right, the pre-2002 versus post-2002 divide. Can you explain the financial impact? How badly were the pre-2002 folks affected?
The impact was severe. It meant a significant loss of real income over time. The calculation method used for pre-2002 retirees, often a graded system, didn't fully compensate for inflation.
So like, if inflation was 5%, maybe they only got a 3% adjustment.
Something like that, yes. And while a small percentage gap might seem minor in 1 year, over 20 or 30 years, it compounds dramatically. We're talking substantial amounts of lost purchasing power.
So you could have two people who did the exact same job, retired maybe just a year or two apart, one side of that 2002 line.
And one person's pension keeps up with inflation reasonably well, while the other's is effectively shrinks in value every single year.
That's precisely the situation. A purely arbitrary date determining whether your retirement income keeps its value or not.
And the court saw that as deeply problematic.
Yes,
They explicitly linked it to the Constitution. The judgment states there was prima facie merit, meaning on the face of it, a strong case that this disparity was arbitrary and violated Article 14.
Article 14, the right to equality before the law. So this wasn't just a calculation error, it was potentially unconstitutional.
That was the finding. Treating two similarly situated groups of pensioners so differently based only on their retirement date raised serious equality concerns.
Okay, if the court found prima facie a violation of a fundamental right, why didn't they just order SBI to fix it immediately? Pay the arrears, apply 100% DR to everyone?
That's an important question, and it gets into judicial practicality. Issuing an immediate order, a writ of mandamus, to fix the DR calculation for potentially thousands of people going back years would be incredibly complex and burdensome.
Exactly. It involves huge actuarial work, complex financial recalculations.
The court recognized the inequality was serious, but also understood that ordering an instant fix without the groundwork could be disruptive and chaotic for the system.
They didn't want to break the bank literally while trying to fix pensions.
Okay, so they acknowledged the inequality, put a marker down saying, this looks like an Article 14 violation,
Okay,
but held back on the immediate compulsory order. They wanted the institutions, SBI and the government to do their homework first.
okay, that makes sense. The Jaipur bench said, we see the problem, we agree it's likely illegal. Now you figure out the detailed fix. Which leads us perfectly into the third part, the actual orders, the structured direction.
Yes, this is where the judgment gets really active. Instead of just ordering money, the court ordered a process, a time-bound action plan.
What exactly did they direct SBI and the government to do?
The mandate was clear. Consider formulation of a mechanism for pension updation in line with Government of India's central pension revision frameworks. They specifically mention looking at the 7th CPC models.
So basically, stop doing your own thing that leaves pensioners behind. Look at how the central government and the RBI handle this and come up with a proper system.
That's the essence of it. It was a strong push towards alignment with broader public sector best practices.
Was there a deadline to avoid indefinite delay?
Yes, there was a firm deadline. The court gave them 6 months to come back and file an action-taken report, detailing what steps they'd actually taken to create this new mechanism.
6 months, that's quite tight for bureaucratic machinery. It puts the pressure squarely on the defendants.
Totally, the burden shifted. Now, SBI and the government had to actively demonstrate progress, not just defend the status quo.
And underlying all this, the court made a point about the legal nature of these pensions, didn't they? Something about pensions not being just a simple contract.
Yes, a critical distinction. The court emphasized that bank pensions aren't purely contractual arrangements between employer and employee. They're not just corporate policy, or worse, charity.
What are they then?
They classified them as a quasi-statutory benefit. Because public sector banks like SBI operate under specific acts of parliament and government regulations, their pension schemes carry a public law character.
Quasi-statutory, meaning partly based on statute, having legal force beyond a simple agreement.
Correct. And because they have this public law dimension, they are subject to judicial review based on constitutional principles like Article 14 fairness and equality.
So failing to update pensions isn't just potentially breaking a promise, it's potentially failing a public, legally enforceable duty.
That's the implication. It elevates the entire discussion. And the court hammered this home with a quote, focusing on the human cost.
What was that quote again?
Retired bank personnel, particularly senior citizens with service of 35 years, must not be consigned to economic irrelevance. It's a direct appeal to dignity and fairness.
Okay, so here's where it gets really interesting, pulling it all together. What's the big takeaway here?
The Jaipur High Court ruling sets a powerful precedent, even though it's from a state-level court. It strongly suggests that PSB pension regulations need to be interpreted through a constitutional lens, aiming for fairness and alignment with central government standards.
It addressed Regulation 56, which the bank treated as optional or dormant.
It turned it into an active mandate for action. The court basically said, this regulation isn't dead. You must use it, especially given the obvious unfairness we see in things like DR disparity.
So it didn't give the pensioners the immediate cash they wanted, but it gave them something arguably more powerful, a structured process backed by judicial order.
Exactly. It acknowledged the injustice, particularly on the DR front, and mandated a formal review aimed at systemic updation, pointing towards the 7th CPC as a benchmark.
So for you, bank elders, what does this mean? It means the court struck a balance. It linked that concept of financial dignity directly to Article 14 equality.
It told SBI et al. That letting pensions stagnate isn't just bad management, it's a potential failure of their public duty.
And critically, it set up the next step. SBI and the government don't come back within that 6-month window with a credible, actionable plan, then pensioners can go back to court.
And this time, they'd have this ruling in hand, strengthening their case for that immediate compulsory order, the right of mandamus, that the court initially withheld. The pressure is now firmly on the institutions.
It really flips the script. So the final thought is this. If a pension is, as the court says, a quasi-statutory benefit and not charity, does the failure to keep it aligned with inflation and current salaries automatically raise that Article 14 question?
Yes. Does it inherently question the value and dignity of the service someone provided several decades ago?
That's the central challenge this ruling poses. Not just to SBI, but potentially to the entire Indian public sector banking industry.
It's a question that's now very much on the table. Between November 7 and 9, we'll release our analysis of the Chandigarh ruling. Until then, thank you, subscribe, share, comment, clip Update ki slippy, and Namaskar as we bow to the elders.